Lincoln County Commissioners on Tuesday, May 24th, 2022. Lincoln County side, will you state whether we have a quorum, please? We do?
We do.
Okay.
Could I get a roll call for city council?
Council members Jensen.
Here.
McCoris.
Here.
Neitzer.
Here.
Selberg.
Here.
Sale.
Here.
Starr.
Here.
Baranco.
Here.
Cole. Tenhaken.
City council has a quorum.
Okay. Would everybody stand and join us for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. On county side, can I get a motion to approve the regular agenda, please?
So moved, Madam Chair.
Second.
We have a motion by Schmidt, second by Aaron's. The clerk call the roll, please.
Commissioner Aaron's?
Yes.
Commissioner Gibbon?
Yes.
Commissioner Schmidt?
Yes.
Commissioner Landine?
Yes.
Could I get a motion to approve the regular agenda from the city council?
So moved, Neitzer.
Is there a second?
Second, Jensen.
Been moved and seconded. Could we please have a roll call vote?
Council members Jensen.
Yes.
McCoris.
Yes.
Neitzer.
Yes.
Selberg.
Yes.
Sale.
Yes.
Starr.
Yes.
Baranco.
Yes.
The motion is approved.
Thank you. We'll move on to regular business. This is a second reading and public hearing for an ordinance of Lincoln County amending the joint zoning regulations for Lincoln County and the city of Sioux Falls by amending Article 9.00 C, Commercial District, Section 9.02, Sub J, Medical Cannabis Establishment. The Lincoln County Planning Commission vote to recommend approval failed 0-5. The Sioux Falls Planning Commission vote to recommend approval failed 0-5.
Good evening, Toby Brown with County Planning. This is an application from Dalton Grimius. This is an application to amend the regulations for medical cannabis, as was just mentioned. Specifically, this would amend the section in the commercial district addressing the residential portion or the dwelling setback portion. And so staff has been in communication with Mr. Grimius for some time. He's identified a parcel in the county, in the unincorporated area of the county, to place a retail type cannabis establishment. Through staff's analysis, identified that there was a conflict use in the area. Specifically, that conflicted use would be a dwelling, non-conforming use. And I'll pull up a map once and take a look at it. But this would be a dwelling that's located within an industrial area zoned I-1 light industrial. Specifically, the dwelling is located within this property here. Per the ordinance, that any dwelling in the area would require a setback of 1,000 feet from the property line of that. So this property would not be allowed. So Mr. Grimius and I visited about potential of a variance to the regulations. Identified through conversations with city staff and legal counsel that this would be a use variance, so that would not be appropriate for that. And so the appropriate step would be to submit an application, which Mr. Grimius has done. Mr. Grimius did draft the proposed amendment, and it was reviewed by legal counsel and staff, but it was not drafted by legal counsel or by staff. And so what the proposed amendment would do specifically would be to take away the regulation or the setback from a dwelling of 1,000 feet to properties that are within the C commercial district, the I-1 and the I-2 zoning district. So essentially, if there was a dwelling, as such the case here, that would be a non-conforming use, is that we would essentially exempt that from the setback. This specific property where there's a dwelling on it, the house was constructed in 1976. At that time, it was within the A public use district. And so it was a legal conforming use. In 1996, the county rezoned the property to C commercial. I can't find anything in the record that that was initiated by the property owner other than the county board motion to do such. I do know that in 2009, when the current zoning map was adopted and then converted to the joint jurisdictional area, that the county initiated that. It was not initiated by the property owner to switch to I-1 light industrial. Mr. Grimius has talked to the affected landowner, and to the best of my knowledge, they've said that they don't have any issue with the use being in there. And so staff analysis on this initially is that, again, this is a policy change, so it's difficult for staff to weigh in other than to tell you kind of what the impacts of what this would really be if you adopt this amendment. Again, adopting this amendment would allow a dwelling that's a non-conforming use in the C, I-1 or I-2 district would essentially exempt them from this setback, from meeting that setback. So both sides of it, if the house is currently a non-conforming use, we treat under zoning, non-conforming uses, legal non-conforming uses, we treat them as standard uses. But on the flip side of it, Mr. Grimius' argument is that he's proposing a legal conforming business too, and so it's a conflict there with it. So planning, as was stated, both planning commissions did recommend denial of the application. This, per the ordinance, the zoning ordinance for the joint, it does allow for an application to be submitted for a text, essentially a text amendment. I know that's different from what the city of Sioux Falls policy is for ordinance amendments, but that is what is allowed under the joint ordinance. With that, I'd be happy to answer any questions that you have for staff at this time.
Anybody have any questions for staff?
Craig Nitzer.
Chair, may I?
Go ahead.
So I'm assuming is the strike through that says is conducted, is that just to clean up because you can't be conducting something until you have it? I mean, is that just a cleanup item?
Again, this wasn't drafted by staff or legal counsel, the applicant. That was how he submitted the application, so, but I've had it reviewed by our legal counsel. They didn't have any issues with the strike through on that part of it, so.
Okay, I'm assuming it's because the measurement would be happening before you've got the use, so is conducted implies that it's already there. I was just trying to figure out what the intent of that deletion was, but did staff on either side, county or city, make a recommendation as it relates to this, or are you neutral?
No, I think in the staff report that I included in the packet that staff identified that this was not consistent with the comprehensive plan, mostly because the treating of the conforming use. And then also in the analysis, we identified that we have a number of uses for setbacks, churches, schools, and all those, and we identified in those that we also didn't specify a specific zoning district. So this could come up later in the future too, is that if there's a church that's in a district that's non-conforming, would that, trigger this aspect as well too? And so, staff's perspective was consistency, and then the comprehensive plan really talks about protection of conforming uses, non-conforming uses. So the staff report does show that the staff did recommend that it wasn't consistent.
The comprehensive plan does indicate that non-conforming uses should also be protected?
Protection of non-conforming uses, yes, through the
Okay.
zoning ordinance, yep.
Do you know if there's any other examples where you'd have this situation where you have residential property in your C zones, or is this kind of an outlier?
It's the only one that I know of, yeah.
But you are mentioning that if this would be a deviation from how you're treating other uses. So for example, if we found a church in your example that was in a commercial zone, then an argument could be made if you did it here, then why are you protecting the church? And you could, this would be a unique instance that you would not protect the house from the cannabis establishment, but would there be other protections in place for this house for other types of uses? Is this just, cannabis, they would not be protected, but there could be some other uses that they would be protected from? Is that the case or not?
So in the commercial and the I-1, I-2 districts, we don't have setbacks for any uses. This is the only setback within those districts.
This is the only one?
Yep.
Okay. Okay, thank you.
Yep.
Thank you. Any other questions?
Thank you.
Thank you. Is the applicant present? You want to come up and state your name and address, please?
Dalton Grimius, Brandon, South Dakota.
Go ahead and speak on your proposal.
The proposal was just to amend the zoning text to allow our use, which is an otherwise conforming use, to not be dictated by a non-conforming use. I mean, the house is on industrial property, and as far as I know, our business type would be the only type that we're protecting this dwelling from. And I felt that that was not really the direction of the ordinance, to not allow a conforming use in an otherwise conforming area.
And did you talk to the owner of the property?
We did talk to the property owner. He did refuse to sign anything under the pretense, or exact wording was, as far as I'm concerned, you don't need my permission. I don't have that written. That is what he has told us. There are other scenarios in other districts that were very similar. Genesis Farms dispensary in Minnehaha County ran through a very similar issue where they had a home on commercial property, but they were allowed to go through that conditional use process that the county had, that we don't have the luxury of using in the joint jurisdiction area.
Mr. Grimius, thank you for being here tonight. Can you give me a little bit of idea about your business, what you do, why you brought the amendment, et cetera?
So we are a vertically integrated cannabis company, have a cultivation facility just down the street from the proposed site, that we currently have the manufacturing, dispensary, and cultivation license all housed under that same roof. But due to the state regulations, we're not allowed to do any extraction or apply any pesticides on that site because there's a on-site dispensary. So our proposal would be to take the dispensary out of our current facility and apply that, or reapply for this facility to have a more retail-focused area versus back in the industrial park.
Would you say that this is an instance of an outlier that we're probably not going to find?
Yes. From what I could find, there is no other situation that this would affect. And really, that the city of Sioux Falls has a conditional use process and can allow us to go through those motions. Lincoln County is very open to cannabis. That the joint jurisdictional area is the most restrictive, to me, makes no sense.
So you've done the research, and in terms of, there being concern about the precedent that gets set here, you're telling us,
It's already the most restrictive.
yeah, what I was going to say is you're also telling us it couldn't be set anywhere because there is no other precedent that can be set.
Right.
Okay, thank you.
Do you have anything else for us?
I don't.
Does anybody else have any questions for Mr. Grimius? If not, is there anyone in the audience that wish to come up and speak in favor of this application? Anyone here to speak against the application? Is anyone in the audience have any questions they'd like to answered?
Madam Chair, can I ask a question?
Yep, go ahead.
Maybe this was addressed earlier, Toby, but I was taking some notes. Can this gentleman here and his business apply for a variance?
No, because it would be a variance to the use of it. So, no.
Okay, so the only way that he can move his business forward is to get, in the way that he's articulated to us tonight, is to have the ordinance changed.
For that site, correct, but he'll still need to obtain a license from the Board of Commissioners as well.
Correct. But this would be the necessary first step.
Correct.
Now, based upon the research you've done, in terms of concern about there being a precedent and all that, is there any other houses situated in these areas where that concern about a precedent being set would be an issue?
Not today, no.
Okay. So really, this is an outlier. This issue is.
Could be, yeah.
Okay.
Yeah.
Any of the joint members wish to speak on the item?
Madam Chair.
Go ahead.
Toby, so are there no other uses in your commercial district that have required separation distances?
Not that I'm aware of, no.
Okay, so this is the only one that has a required separation distance at all?
So again, this property is zoned I-1 light industrial.
Okay,
But
I'm
because
sorry.
it's a permissive use, we allow a commercial, because in Lincoln, in the joint ordinance, medical cannabis establishments are only allowed in the commercial district as permissive uses. Because they're permissive uses, we allow them, and if they're zone light industrial, to be permissive uses in that district as well.
Okay,
Madam Chair.
thanks.
Go ahead, Commissioner Schmidt.
Ellen, is this the only site that you could have? I mean, I'm not picking anything, but there are multiple areas, but you picked a site that needed action on the part of a joint by the city council and the commission. Was there no other sites for your consideration that would have met your particular needs without having to go through all this?
Nothing that we could find. Real estate in the joint jurisdictional area where we really want to be is hard to find. That is commercial or light industrial and has all the other setbacks for distance from home. This, where we have just one house dictating that we can't have a otherwise conforming use, is about the only place we could come up with. That was for sale, that wasn't exorbitantly priced.
Okay, thank you.
Any other joint members have questions, comments? Go ahead, sir.
And this might be for staff, so in this area, and I don't have the map up in front of me, but anyway, so in this area, in the 1,000-foot setback, are there any developments that are going to happen in the future that would go against the 1,000-foot setback?
So I'll pull out this other map.
And thanks for popping up here again.
Yeah, no problem. So yes, there is a house in this development that is zoned A1 that even with this change will not be affected by the setback. It will still, the setback will still count, I guess, is what I point out.
And what I'm saying is if you look on the top right where you see Sioux Falls, those are houses, right?
Yep.
Are those impacted by, are those in the 1,000-foot range?
Not
Or-
now, no.
And then any of that to the south, you know, right where your mouse is right now, is any of that gonna be residential development? Or what would the zoning in our joint jurisdictional area be there?
Toby, can you pop back to that circle area on your supporting documents that you had?
Yes, I wanted to point out this one too. So that there is a house. So this change tonight is not going to affect this property. So it only affects those properties that would be non-conforming uses. So this property here. So this property is zoned rural or zoned agricultural, has a dwelling on it. His father was the one that developed the park. That does count, so the 1,000 feet does trigger some of those properties there. If there's a house that's built here or a house that's built here, those will not be exempted by this amendment tonight. The amendment tonight is only exempting a structure that would be essentially a dwelling that's zoned zoned commercial I-1 or I-2. So yes, further growth in there will impact that area, but if they're existing, it's existing. But this proposed amendment really just addresses a non-conforming use that's here that affects this particular property is where Mr. Grimius is looking at.
Let me expand on his question.
Yep.
There's nobody looking at building a housing subdivision in that red box on the map, is there? that you know of.
That I'm aware of, no.
And there's nobody looking at building a housing subdivision just to the north of it that you're aware of?
Not that I'm aware of, no.
Okay. Thank you.
Any other members have questions or comments? Quiet tonight. If not, I'll ask for a motion to approve.
Sir, I'm very sympathetic to the fact that I appreciate you tried to speak to that homeowner, and that you did speak with the homeowner. And I understand how sometimes it can be very difficult to get the information, something signed that you would need. It does make me a little bit concerned that we don't have that testimony or some kind of a signed document so that I can be confident that, I understand that it's not the be-all, end-all of this discussion, but that would be information I would have preferred to have. I'm sure you feel the same.
I would have preferred to have that as well. That would have helped a lot and made me feel a lot better, and that's why I wanted to make sure I addressed that when I was up there speaking to it. I don't have anything written from him, but that is word to word. As far as I'm concerned, you don't need my permission.
Well, we're here tonight and nobody's here to speak against it, so I think that speaks volumes.
This home is occupied, right? It is lived in?
Yes.
Is there any other things that, this is his sole proprietor? Or does he have a business or related, and since it's in a commercial?
He runs a business out of the shop right next to his house, Twisted Choppers. So it's not just a house, like he knows that he's in an industrial area, and that's probably why he purchased the property, is because he could do both.
Okay.
Madam Chair, may I?
Sure.
Staff I don't know, in the joint jurisdictional boundary, are there required notifications, like we know that the landowner would have been sent a letter or notified that this meeting was happening?
No.
Okay. But, okay, the person here is asserting, but we don't know, I guess. The neighboring landowner wouldn't have got a letter saying there's a rezoning happening or proposed, well, this is just an ordinance change. This isn't even okay, so they wouldn't have been officially notified.
We don't send out, Toby, do we send out letters anytime we change ordinances?
Yeah, if it was a petition zoning change, yes.
Yes, but this is an ordinance, okay.
Yeah, it's a countywide ordinance, and I know it affects this particular property, but it affects.
Yeah, yep, got
countywide,
it.
yeah.
Okay, thank you.
If I could, one thing too, we'll still have to go through the hearing process for our use. And that would be notified, correct, Toby?
Would that be to obtain the county license, or
Yes,
is that what he's referring to?
yes.
Okay.
So ostensibly, there will be notice provided, and this guy, the one guy who's holding this all up, who says he's okay with it, he'll get another chance, he'll get another bite at the apple to show up here if he wants to, right?
Right.
Okay.
All right, any other questions or comments? If not, I'm going to close testimony on the item. Consider a motion to approve.
I'd like to make a comment.
Go ahead.
about this. These rules and ordinances are recently passed by a lot of governing bodies, certainly Lincoln County and the city of Sioux Falls. And I really hesitate to start making one-off exceptions before the process has gone through. I would personally think that if we were 2, 3, 4 years into the process, and then we needed to take a look at a one-time exemption for one thing, I'd feel a lot more comfortable. At this point, being so new in the process, I don't feel comfortable making an exemption, an ordinance change for one specific place. So that'll be my position when we vote.
Thank you. Anyone else wish to make any comment?
Madam Chair.
Go ahead.
Whoa, I did pull that closer to me. Sorry, I'll sit
Go
back.
ahead, sir.
I agree with Counselor Sale. I guess that we're new, but part of it is we didn't know exactly where we were going to end up or how we were going to get here. And this one is exactly the policy that I disagree with and voted against, but at the same time, the policy for the city of Sioux Falls is to push these dispensaries, pharmacies into outlying areas of the city. And if we're not going to put it here in an industrial park where we pretty much hide it, which is what our intent was when we set the city policy, I'm not sure where else we're going to put them then. And if it's our goal to totally regulate them out of business, which I feel like we do sometimes, this is exactly the location where our policy says this type of facility should be. And do we have to make, I mean, I don't know what the amount of time is before we make a change. This really, I don't get where else you would do this. And I don't get when you buy a residence in an industrial park, how you would not expect other industrial activities going on around you. Yeah, he was there first. This cleans up a small mess that, we couldn't have anticipated when we passed this. Because again, our goal was to push it into industrial areas where the general public couldn't see it or couldn't be involved in the process. So if we don't allow this here, let's just say we don't allow them anywhere then, because that's really what this comes down to. Thank you.
Thank you. Anyone else?
Madam Chair, I'll move for approval of the ordinance.
All right, is there a second?
I'll second it.
Thank you. I have a motion and a second.
Madam Chair, if I may.
Go ahead.
Mr. Grimius, thank you for bringing this forward. This is a example of direct democracy. You've got an opportunity to put on the agenda what other people can't. And we allowed text amendments you get a hearing, and you get all the folks who are elected in office to hear you and hear what you have to say, and you've brought something forward that ordinarily would not have been identified as an issue. And you've done it because you're in the industry and obviously it affects you. So thank you for bringing it forward. Obviously, medicinal marijuana, there's just some people who still don't like it. And they're going to find any excuse to not want to support the industry. In my mind, we don't, need 3 or 4 years in order to identify problems to fix them. You've identified a really unusual one-off instance where you can't move forward with your industry, which is medical cannabis. It's not recreational or anything like that. And so you've got this one guy living out there in a house who apparently says he doesn't have a problem with it. And he'll have an opportunity to come in again under our ordinances if he does have a problem with it. And we've got planning and zoning saying there's no housing subdivisions planned out there. Nobody wants to build out there in a residential manner right now that we know of. And even if they did, there's still some protections built in for those residences anyway, because it only applies to certain zoning ordinances. So we need to move forward now. We can do so confidently that the public is going to be protected. And really, at the end of the day, what are we protecting the public from? Medicine. And so I'm happy to support this. I'm happy to be able to allow people to be able to get the medicine that they want. And it was widely supported in the polls a few years ago. And this just simply clears up, I think, what is a 1 in a million obstacle that you've accurately identified, but it's still, this change in the ordinance still protects everybody. Kids aren't going to be able to drive past on their bicycles and get medical cannabis. So I'm going to be happy to support it because it still protects the public, still protects the kids, still protects schools and things like that. It just clears up a one-off incident. So thank you.
If I might.
Go ahead.
Yeah, thank you for bringing it forward. I guess where I'd lean towards, I think Counselor Sale made a good point, but so did Counselor Starr. And I think the Commissioner just made an also a very good point where I'm kind of leaning in that direction where it is unusual, it is a one-off situation, and if not here, where? And I think that it has been talked through, and I think we can be confident that the people are protected with this, so I believe that I will be supporting it. So thanks for bringing it forward, and certainly unusual topic for sure, which I'm sure it's the first of many we'll probably come across as we go forward in the years to come, as Counselor Sale talked about.
Thank you. Any other comments or discussion?
Yeah, I've got an additional comment. You know, I came into this, I want to show respect and deference for the underlying panels that voted, but I have heard some information here tonight that caused me to have some question. Is it absolutely necessary that we reach a final decision, or would it be appropriate to have time to gather additional information?
I mean,
Matt.
there's a motion on the table, so I think we're gonna
Okay.
move on that motion, and then if there are subsequent motions, we can talk about that, but there is a motion and a second that's been made. So if there's no further comment or discussion on the motion, I'd ask the clerk to call the roll.
Commissioner Aaron's,
Yes.
Commissioner Gibbon,
Yes.
Commissioner Schmidt,
Yes.
Commissioner Landine.
Yes. Motion carries on the county side.
I'll look for a motion to approve from the city council.
Move approval?
Second, Star.
Moved and seconded.
Mr. Chair.
Discussion?
Mr. Chair. I agree with Counselor Bronco in the fact that now we could ask the question, but I don't think that they're going to be ready for sale before our next meeting, which would be June 28th. So, you know, if we would be able to defer this to the 28th of June, I think that there'd be more conversations that could be had. Maybe the applicant could, you know, work with the adjoining landowners and talk with them about their, you know, their plans, specifically the individual that this impacts. Because I understand what the county has done, and I appreciate their vote. But I'd like some more time to do a little more due diligence on this, and I don't think it's gonna be ready again to dispense medical marijuana before the 28th. So, you know, I would make a substitute motion at this time to defer this until our joint meeting on June 28th at this time.
Second?
A substitute motion to defer to 28th of June. Any discussion on that?
Can I ask a question?
You sure
All
can.
right. Sir, how's it gonna affect you if this is tabled, if at all?
Slow us down.
Expense to you?
Expense, we're in the middle of build-out of our current facility, so we really have to make a decision quickly on where I need to allocate funds. So delaying another 2 weeks it's been a 3-month process. And I do have a contract with the current owner on the table that will expire.
When does it expire?
I don't know off the top of my head.
Any other discussion? Let's take a roll call vote on the motion to defer.
Council members Jensen,
Yes.
McCurris,
Yes.
Neitzer,
No.
Selberg,
No.
Sale,
No.
Star,
No.
Baranco.
No.
Motion to defer has failed. Let's go back to the original motion to approve by Selberg and Starr. Any other discussion? Counselor Neitzer?
You know, it is kind of a close call in that generally you do want to protect non-conforming uses, but as I'm taking in all of this information, I'm going on the assertion that this neighbor was aware of this meeting and there has been discussions, and the fact that said neighbor is not here, I take something from that. I cannot speak for everybody else who sat on the task force that we sat on, but I know what I was going for, and the idea was to have these located somewhere like this. This is where they were supposed to be located. I think you probably have a very unique one-off situation where you have a unique use that is potentially disqualifying an entire area from running a business where there's nowhere else really that it could run. The fact that this particular use has this 1,000-foot limit, and there's not a deviation from it. So you can't do like a conditional use if it's less than 1,000 feet. It's just 1,000 or none, correct? So he doesn't have the option to do a conditional use where there would be a public hearing and a neighbor could come and say, hey, I have an objection to this. And so it's really an all or none here. I am also persuaded by the fact that it doesn't appear that this would essentially set a precedent literally because this is the only residential use that is in a zone like this. So taking all of those into consideration, I think, sometimes we just have to use some common sense. And in this particular case, I'm going to support this ordinance change because I still think it's in keeping with what we were trying to do in terms of where they would be placed. So, thank you.
Thank you.
Other discussion? Hearing none, we have a roll call vote of the council, please.
Council members Jensen,
Yes?
McCurris,
Yes.
Kneitzert,
Yes.
Selberg,
Yes.
Sale,
No,
Star,
Yes.
Baranco.
Yes.
that motion is passed.
All right, good luck. Yep. All right, we'll move on to our public input. Anybody that wishes to address the commission, the joint members, come on up. You'll have 5 minutes. State your name and address, please.
Sweet.
Good evening. My name is Chad Bishop. I live at 7405 South Valencia Drive in Sioux Falls. Got a whole 5 minutes. I'm not sure what I'm going to do with that. The theme here is the science did not change. The data changed. That should have been expected. Those who are creating policies and making statements in terms of absolutes represent the science poorly and should have had more humility and caution until the data was more mature. This may be repetitive, but I am here to help bring the new city council members into the discussion. So Councilmember Baranco, McCurris, and Cole. Tonight, I'm again asking you to alter the city's COVID-19 vaccine outreach campaign to inform parents of their ability to screen their child for prior immunity before having any of the COVID-19 vaccines administered to them. In addition, I'm asking for you to consider subsidizing screening for prior immunity by reimbursing families for SARS-CoV-2 antibody or adaptive T-cell response assays. I'd like to draw your attention to the CDC's morbidity and mortality weekly report from April 26th, where they highlight their use of screening for anti-nucleocapsid or type N antibodies, which we've discussed before, to determine that 75% of children nationwide have been infected with SARS-CoV-2. It's probably higher in this state. This is just one of the 28 antibodies, if you remember my candy demonstration, that are not conferred by administration of the COVID-19 vaccines on offer. Only the type S antibody is. Given this study and the probability that the children of Sioux Falls and Lincoln County are already likely to have natural immunity, what is the benefit to them to receive additional vaccination? We've discussed the CDC's reporting on that number prior. Given the risk stratification for COVID-19 that we have covered a dozen times, that of a 80-year-old diabetic obese person to that of a metabolically healthy 10-year-old, what is the risk and what is the reward specifically for children? I would remind you that the risks of vaccination are not zero. I would also draw your attention to the Reuters report that was a few weeks ago, with the headline stating U.S. limits the use of J&J's COVID vaccine on blood clot risks. Those links are in the QR code link document. I ask again, is it the case that the evolutionary cycle of the beta coronavirus outstrips our ability to safely match it with a vaccination program? Is it the case that one prominent reason we have never had a human coronavirus vaccine approved in the past is because the immunological community understood this? Jobs were threatened and coercion employed when the vaccines purportedly prevented infection and transmission, but we now know they do not. No consideration to previous infection was given. However, if you remember, Sanford announced their Survive program where they were going to test their own and frontline employees to determine at what rate they went seropositive. And then a year later, that data was never published. Remember that. It was pure science. How many folks do you know who contracted it post-vaccination? How many folks do we now know who contracted it more than once? Have any of the experts available to Sioux Falls City Council or the Lincoln County Commission brought up the topic of the original antigenic sin, or its variant, the antigenic distance hypothesis? I'd look it up if I were you. On Mother's Day, while I walked into the original pancake house to celebrate with my family, my father seized right in front of me inside the crowded entryway. I had to grab him around the chest with both arms to keep him from falling. After struggling to get him onto one of the benches, it took a few minutes before he recovered. It's an eerie thing to watch a human just not respond for minutes at a time with their eyes wide open. It's heartbreaking, especially when it's someone you love. In March, I conveyed the story to this body of how our family worked with the physicians for 9 months, resulting in a diagnosis of petit mal epileptic seizures for my father. He presented these symptoms for the first time 11 days after the first dose of the Pfizer vaccine. We would like the people to know that the Journal of Neuroimmunology states it this way: healthcare providers should be aware of the possibility of post-vaccination epilepsy. This process took us 9 months. Imagine a family less persistent dealing with this. How many just stopped asking questions? How many were shamed into compliance? How many doctors would even pursue it? The day after the statement to this body, the first Freedom of Information Act data dump from the Pfizer approval submission was provided. You will find petit mal epilepsy seizures among the adverse event reporting, specifically on page 21. Thank you for your time.
Thank you. Any other public input? Anybody want to come up and speak? If not, we'll consider a motion to adjourn.
Move to adjourn.
Is there a second?
Second?
Thank you. Will you call the roll, please?
Commissioner Aaron's,
Yes.
Commissioner Gibbon,
Yes.
Commissioner Schmidt,
Yes.
Commissioner Landian.
Yes.
Can I get a motion to adjourn from the
So
council?
moved, Jensen.
Second, chorus.
It's been moved and seconded. Could I, let's just take a voice vote. All in favor, say yes.
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 Opposed, say nay. Passed. We're adjourned.
We're adjourned.